And we're live. Good evening, everybody. I'm Paul Gullickson, Communications Manager for the County of Sonoma, and we welcome you to Sonoma County's Tenant Protection webinar. Before we begin, I'd like to introduce our interpreter for this evening, Julie Burns, for a brief word for our Spanish-speaking audience. Julie?
Thank you, Paul. Muy buenas noches. Bienvenidos al seminario sobre la protección de inquilinos. Este seminario será interpretado simultáneamente al español. Si desea escuchar en español, por favor haga clic en el icono del globo o en el círculo donde hay 3 puntitos para elegir el canal de español. Si quiere hacer una pregunta, esta será traducida al inglés. Thank you, Paul. For any English speakers, if any comments are made in Spanish or questions, those will be interpreted into English, and you can hear the interpretation by clicking on the interpretation icon or the 3 dots at the bottom of your screen and choosing the English channel. Thank you. Back to you, Paul.
Thank you, Julie. We appreciate you being here.
Thank you.
On September 17th of this year, the Sonoma County Board of Supervisors adopted an ordinance that provides new rights to tenants in the unincorporated areas of Sonoma County. These new county protections are in addition to the rights that are already covered under the California Tenant Protection Act. That is a state law that was passed in 2019 that limits rent increases and requires landlords of many types of rental units to have a just cause to evict a tenant who has lived in a property longer than 1 year. Just cause evictions, as they're known, are allowed for such things as non-payment of rent, lease violations, or criminal activity. Under the new county rules, tenants are now protected by just cause requirements as soon as they begin renting. This eliminates the 1-year waiting period that was required under state law. State exemptions for subsidized housing from just cause protections are also removed in the county's new ordinance. These are just some of the new protections that the Board of Supervisors have approved. The supervisors also wanted to make sure that tenants understand their new rights. So this evening, as part of our ongoing tenant outreach campaign, you will hear more details about the county and the state legal protections for renters, as well as it will also provide an opportunity for you to ask questions about these new rules. If you have a question, please feel free to go ahead and put it into the Q&A box in this Zoom webinar. Or if you're watching on Facebook, this is being streamed live on social media, leave your question in the comment area. Or you can also email questions to us at publicaffairs, that's one word, at sonoma-county.org. And at the end of our initial presentation, we will begin fielding those questions and getting answers for you. Our panelists for this evening include Elizabeth Coleman, Deputy County Counsel in the Sonoma County Counsel's Office, as well as Patrick McDonald from Legal Aid of Sonoma County. But before we get to our legal experts, I'd first like to introduce Supervisor Chris Corsi, who represents the 3rd District of Sonoma County, which is Santa Rosa in the central parts of the county, including the Roseland area. Supervisor Corsi has been a champion for tenant rights and voted in favor of the ordinance that we will be talking about this evening. So with that, let's welcome Supervisor Corsi.
Thanks, Paul. Happy to be here. I do represent the 3rd District, which includes all of Southwest Santa Rosa, including Moreland, the downtown areas, South Park, down Santa Rosa Avenue, and into most of Rohnert Park. This is a webinar that is intended to educate people about our new residential tenancy protection ordinance. It's also known as our just cause ordinance. So you'll hear that phrase a lot tonight. The idea of this is to promote neighborhood stability, prevent homelessness, while still ensuring landlords a fair and reasonable return on their investment. It's the idea is to take some pressure off what is a high pressure housing situation in Sonoma County. We understand that, and we hope this helps. We'll talk about tenant protections and just cause, but it's important to understand, whether you're a tenant or a landlord, that this ordinance does not prevent evictions from happening. What it does is require a just cause for a landlord to pursue an eviction of a tenant. Tenants still have to pay their rent. They have to abide by their rental agreement, but they do have some new protective rights, which we'll explain tonight. It's also important to understand that this is a county ordinance. It doesn't apply if you live inside a city such as Santa Rosa or Petaluma or Cloverdale. And because of state law, it doesn't apply to rentals of single family homes. So does this sound complicated? You bet. We understand that. And that's why we brought lawyers with us tonight. They're going to be happy to answer all of our questions. And with that, I just want to say welcome to our webinar. I'll turn it back to Paul, who will introduce us to some lawyers.
Thank you, Supervisor Corsi. We'd now like to turn it over to one of those lawyers, Elizabeth Coleman from the Sonoma County Counsel's Office, who will give us an overview of these new county tenant protections. Elizabeth?
Thank you, Paul. Thank you everyone for being here. I'm Elizabeth Coleman. I'm one of the deputies in County Council, and I have been working on tenant protection matters for the county for the last few years. The current ordinance arose effectively out of the COVID protections that the county passed in early 2020. Initially, the county had protected tenants from eviction for non-payment of rent related to the COVID emergency. And several months later, the Board of Supervisors voted to expand protections to limit the number of potential bases for evicting folks during the COVID emergency. Unsurprisingly, having a near moratorium on evictions significantly limited the number of evictions that were happening in the county. So when those protections began to expire, tied to the time frame that state law set for other protections, the conversation became around what could be done going forward in order to provide tenants more protections coming out of the acute part of the COVID pandemic. So after the board received an update on the status of what types of, what the results of the protections during COVID were, we were, as staff and council, directed to come back with a menu of options that the board could consider that could go above and beyond the state level protections for tenants in the realm of eviction. So early 2024, we returned to the Board of Supervisors and presented a matrix of all of the options that the board could consider to expand the coverage that was already in existence under the Tenant Protection Act of 2019. And also to talk about the manner in which we could reach out to the public to get public input about what types of protections would be most appreciated by the community. So after doing the public outreach and further discussion, the board approved an item which was finally adopted. That is, the final adoption occurred in September of this year with several components to it. And I will do my best to describe them in simple terms, but it's a fairly complicated law. So please forgive the density of this segment of the presentation. So in terms of the substantive protections, the new protections increase the coverage from the perspective of starting tenant protections on day one of a covered tenancy. So any tenancy that begins that is intended to be an ongoing tenancy, not just a temporary residence like a hotel. On day one of the tenancy, the just cause protections that otherwise would apply in state law attach. There are exemptions in state law from the coverage of the just cause protections for income restricted properties, which means that folks who live in low income housing are not protected by the just cause protections. And the county's ordinance removed that exemption. So now folks who live within the unincorporated areas, as Supervisor Corsi pointed out, folks who live in those types of properties are now protected. Regarding the non-payment of rent, non-payment is still a proper basis for a just cause eviction, but the new language approved requires that a tenant be behind more than 1 month's rent in order for an eviction to be an appropriate remedy. So the noticing procedures that are set out by state law still apply. Those, 3-day notice to pay rent or quit notices that come before an eviction, but the amount that must be due has to be more than 1 full month of rent, which means that if folks get behind, they aren't evictable 3 days later. It's a 30-day window effectively. That limitation can only be applied twice per year. So it is not the case that a person can be a full month behind on their rent, all the time and not be evictable. Twice per year, a person can avail themselves of the protection from eviction because it has not been more than a 30-day period of non-payment. There has been also an increase in relocation benefits where tenants are evicted, where it's a no-cause eviction. So the state law procedures set up 2 different ways an eviction might happen. One is where a tenant has done something you'd consider at fault, and those don't have any sort of relocation benefits associated with them. But state law requires that if a person is evicted through no fault of their own, these are reasons like a property being taken off the rental market, or there needs to be a substantial remodel of a property. In those instances, state law requires that 1 month's rent either be credited to the tenant or paid to the tenant. So Sonoma County's ordinance has augmented that relocation benefit to say it has to be the greater of 1 month's actual rent or the fair market value as determined by the Housing and Urban Development Department. So if you're paying below market, you will be able to get credit for the amount the rent should be for a rental unit of that size in the county and not just what your actual rent is. The ordinance also increases, there are some new noticing requirements associated with the ordinance. So all landlords within unincorporated Sonoma County should now be informing the county when they evict a tenant from a property, and the tenant protection portal that's being created right now will have the forms up before those terms go into effect on January 1st to make it easy for landlords to submit that information. It also requires that for tenants who are covered by the augmented just cause, that landlords provide them with certain information in English and in Spanish about their rights. So those are the basic just cause related protections. There is one other major section of the ordinance, which is the prepositioned emergency protection from eviction. And depending on the nature of the emergency here, the board can invoke the emergency protections for more than just the unincorporated area. So just like the county took countywide action during the COVID emergency to protect folks from eviction based on their power under the Emergency Services Act as a subdivision of the state, in a similar emergency, the Board of Supervisors, using the new language, can pass in the declaration of emergency, can invoke emergency protections. And if they do, tenants cannot be evicted except under very limited circumstances, such as a threat to health or safety or the immediate removal of a property from the rental market. So that would mimic the type of protections that existed in the height of the COVID pandemic, where the board makes the affirmative finding that those protections are needed under the circumstances. So those are the basic terms of the revised language as the ordinance is adopted to change state law. And I'll kick it back to Paul, who I think is going to tee up legal aid for more specifics.
Thank you, Elizabeth. We really appreciate that. Well, yes, indeed. Let's go to Patrick McDonald from Legal Aid of Sonoma County, who will give us an overview of this, the California Tenant Protection Act, as well as provide some resources for tenants. Patrick?
Definitely. Thank you, Paul, and thank you, Deputy Counsel Coleman. My name is Patrick McDonald. I am the Housing Team Supervisor and Housing Policy Attorney at Legal Aid of Sonoma County. I have a brief presentation that I'll show everyone. So I'm just going to pull up my screen here. Let's see. All right. And are folks capable of seeing the presentation on the screen? Can I get a thumbs up? I got a nod from Supervisor Corsi. Excellent. So first, and I'm going to try not to be too duplicative of what Deputy Counsel Coleman just stated, but there are essentially 3 stages at which one can track what we call an eviction, right, with data. One would be the eviction notice stage. All legal evictions start with an eviction notice. There has, to this point, been no systematic tracking of eviction notices of any kind in Sonoma County. The Board of Supervisors with the ordinance is now changing that. The second stage would be the unlawful detainer filing. An unlawful detainer is a term of art for an eviction. These are the eviction cases that actually make it to a court case or a lawsuit. And so you can see in the presentation that we've had varying numbers of filings. Like Deputy Counsel Coleman said, 2019, we had a little over 930 cases filed against tenants, so asking that the court issue an order to evict or remove the tenant. 2021, we were in the middle of the COVID era with very strong protections at both the state and the county level. The number dropped considerably down to a little over 300. 2023, almost all of those protections had expired. We went back up into that 900 area. So it demonstrated that to the extent that the protections were designed to keep certain households in place, prevent them from being displaced by the aftershocks of the COVID pandemic, it was largely successful in doing that. The last stage at which one can track an eviction is when the tenant actually receives a judgment against them. So a judge has ordered that the tenant be removed, and the landlord goes to the sheriff's department to conduct a lockout. So you can also see the numbers that we have for sheriff lockouts for that same period of time. 500 in 2019, dropping considerably to 230 in 2021, back up to about 450 in 2023. So those are the 3 stages. We have data on the filings and data on the lockouts, but heretofore, we haven't had any data on the notices, which is something that the county has elected to change here. So I'll talk briefly about the state protections that have existed since 2019. And so we start with the legal baseline, which is that a tenant who is on a month-to-month lease, which includes a tenant whose lease has expired, can be terminated at any time for any reason or for no reason at all. Now, the landlord does have to give a notice to terminate that tenant, but they do not need to have a cause to terminate that tenant if they're merely on a month-to-month lease. The California legislature in 2019 elected to change that. They put in these protections that Deputy Counsel Coleman had summarized, requiring, among other things, a just cause to evict certain tenancies. So trying to remove those evictions that occur for no reason at all. So there are 2 kinds of just cause eviction. There's no fault just cause, which is something that is not the tenant's fault, right? The tenant did nothing to cause the eviction. And those where the state law applies requires a relocation assistance of 1 month rent. And then at fault just cause, which as Paul, I believe, summarized, right, includes tenant not paying rent, lease violations, property damage, etc. Those protections are only applicable after 1 year of tenancy, and there are pretty significant exemptions in the law. So single-family homes are almost all exempt. Deed-restricted subsidized housing is exempt, as Deputy Counsel Coleman stated, and also housing that is less than 15 years old is exempt. So understanding that as the legal baseline that we've inherited from the state, the next slide will show kind of what the county ordinance does in terms of the existing state protections. So we see that the state protections that become applicable after 1 year of tenancy, those protections are now applicable at day 1. So starting day 1, if a tenant is on a month-to-month lease, the landlord does need to have a reason to evict them. Now, again, that reason doesn't need to be the tenant is at fault, but there does need to be a legally substantial reason to evict the tenant. The relocation funds, which under the state law are equal to 1 month rent, are now either the greater of 1 month rent or the actual rent. In terms of the most significant exemptions, and there are multiple exemptions under state law, but I highlighted the 3 largest and most important ones. The county's ordinance does not change the exemption for almost all single family homes. It doesn't change the exemption for housing that is less than 15 years old, and that's 15 years on a rolling basis. So it's 15 years from today's date going backwards. That exemption goes unchanged. It is the subsidized housing or deed restricted housing that has been removed as a category of housing that is exempt. In other words, if a property is exempt, the tenant can be removed without a just cause. If the state law applies or the ordinance applies in the case of subsidized housing, the tenant, after starting day 1, will the property owner will have to have a legally valid just cause to remove the tenant if the property is covered by the ordinance or by state law. As I said, there has been previously no systematic tracking of eviction notices in the county. The eviction notices for all properties are going to start to be tracked in a county portal that county staff will be able to talk a little bit more about. And that's going to apply to all properties, not just those that are covered by the ordinance, so that the county in the unincorporated area has good data on where folks are being evicted and why they're getting evicted. And as Deputy Counsel Coleman talked about, there is no emergency disaster related protections under state law, but the county has gone forward based on the lessons from COVID and wildfires to create a disaster moratorium that again is triggered by the county upon a declaration. So it does require an affirmative county action in order to trigger those protections. Lastly, as Deputy Counsel Coleman pointed out, eviction notices are required to be in both English and Spanish to try to ensure that those who are monolingual Spanish speakers in our community understand the legal process that they are in when an eviction notice is issued. And for non-payment of rent, a tenant cannot be evicted for an amount equal or less than 1 month rent, but that can only be used as a legal defense twice a year, so that tenants aren't able to be sort of perpetually less than a month of rent behind. And I'm not sure if this presentation is capable of being shared with attendees. I'm certainly happy with that being the case. And if it is, there's links to both the text of the Tenant Protection Act, which is the state law I've been discussing, and the text of the county's ordinance. And the last thing I'll mention is that my agency, Legal Aid of Sonoma County, we are the largest provider of free housing legal services for folks who are low income in our community, both in unincorporated Sonoma County and throughout all of the 9 cities here in Sonoma County. The line or the phone line for our housing team is right there, 707-843-4432. And we have a sister organization that is active here in the county, California Rural Legal Assistance. It's a smaller team, but they are also housing experts, and their number, 707-528-9941, is right there on the presentation as well. So with that, I will send it back to Paul, and I believe we'll have time for question and answer.
Yes, thank you, Patrick. And to follow up on your question, yes, we would be happy to share with anybody who requests. You directly email your presentation if they just reach out to us at publicaffairs@sonoma-county.org, and we'll be happy to provide that. And so anyway, thank you for that. Okay, as Patrick said, we'll now be taking questions from our audience. As a reminder, if you have a question, please enter it in the Q&A box here on the webinar. You'll find it at the bottom of the page. Just enter your question. If you're following us on Facebook, please feel free to leave your question in the comment area. And we have people standing by to forward them to us. Also, if you would like to email your questions too, you can email those to publicaffairs@sonoma-county.org. Okay, let's start with a couple of questions. Elaine from unincorporated area of the county asks a question that I think you've already addressed, Patrick and Supervisor Corsi, but I just wanted to go ahead and share it anyway. She said her question has to do about rights of a senior tenant in a no-fault eviction, but this seems to concern a private owner of a single-family home. She asks, can you please advise me who to contact? Are there any extra protections for seniors, even if it does involve a single-family home? Patrick, do you want to take that one?
Sure. So there are no specific protections either in state law or in the county ordinance that apply specifically to seniors. That said, many senior citizens have disabilities that is just sort of naturally sort of come as we age. I believe it was President H.W. Bush who said that we are all temporarily able-bodied citizens. So many of my clients who are senior citizens might have certain protections, not necessarily from eviction, but certain protections throughout the eviction process through reasonable accommodations on account of any disabilities that they might have. In terms of what a specific reasonable accommodation might be, it depends on the disability and the exact stage in the eviction process they might be, or even if they're prior to the eviction process and they need a reasonable accommodation to make their rental housing more accessible to them. That is something that my agency can help with. And there is also a sister agency called Fair Housing Advocates of Northern California. They're also a nonprofit law firm, free legal services, and they practice specifically in the area of disability law and other fair housing issues. So our number for legal aid is good. If there's any concerns or questions about the Americans with Disabilities Act and the California state law equivalents and what rights senior citizens might have under those laws.
But just to reiterate, this law does not cover single family homes, which are still exempt under state law, correct?
Correct, and no special protections for senior citizens.
Okay,
And
thank you.
Just to add a little nuance to that, most single-family residences are not covered, assuming they are owned by normal everyday folks. If they are owned by real estate investment trusts, the rules are sometimes different. But if you have a mom and pop type landlord, those are still exempt under state law.
Okay, thank you.
Paul,
This is
Paul, can I
Yep.
just say that it sounds like the person who asked this question might want to give a call to legal aid.
sounds I agree. And thank you, Patrick, for leaving your number. Okay, Supervisor Corsi, since I have you here, I'm wondering if you might be willing to answer this. I know communication about the new tenant protections was very important to the supervisors. This comes from one of our Spanish-speaking audience members. Mario asks, how are you going to make sure you educate the community that historically never gets involved in issues that affect their lives, communities that speak another language or dialect, and communities that are out in unincorporated and rural areas? And he particularly asks that we not say we're going to depend on nonprofits. He claims they generally do little or no job of connecting with the community. He was just asking mainly, how are we as a county doing that? What do you want to answer that, Supervisor? Of course, I'm happy to help as well.
No, the board, when we made this decision, we also directed staff and committed ourselves to getting the word out to the people most affected by this. That includes the Spanish-speaking community. It includes the senior community, the disabled community. This is our first shot at that. Mario, thank you for joining us. This is not our last outreach effort here. And I would just invite you, Mario, to, if you have ideas for us, please get in touch with my office. It's chris.corsi@sonoma-county.org. And happy to hear any advice you might have or ideas for us. We try all the time it's never enough. We can't get in touch with every person in this county, but the more, the better. That's the idea behind this effort. It's why we're here tonight.
Great. Thank you very much. Shelley asks, where can I get a
Actually,
oh, go ahead.
Paul, I'm sorry,
Yeah,
can I say
Lois?
something? I
Yeah.
just want to let folks know that in District 1, the county is also planning in-person meetings. So we have an in-person meeting scheduled in District 1 on December 4th. And we have a meeting scheduled in District 5 on January 30th. And we're working with Supervisor Corsi on a date in District 3. And there will be advertising, but we are doing outreach for in-person meetings in the various districts around the county.
Thank you, Lois.
And Lois, while we have you on, would you mention the webinar we have for landlords that's coming up in November?
Sure, that's scheduled for, well, when we just recently scheduled it, it's November 19th. It's going to be at 6 p.m. and it's going to be a similar format to this webinar. And advertising is going to go out for all of these events probably next week or the week after. So, but November 19th is specifically for the landlords.
Yeah, and we want to note that there's other communications, part of a communications plan that to push out this information through our newsletters, through radio, through various formats, that will be part of an ongoing campaign, as Supervisor Corsi mentioned. So we're happy to be part of that.
Thanks.
Okay, Shelley asks, where can I get a complete report of the new tenant rights laws, as well as the previous laws that are still in effect? Shelley, I'm going to ask my staff to post a link to the county's new ordinance, and I believe Elizabeth just shared with us some information that we'll link as well.
Yes, Paul, if you could put that up, one of the documents is the text of the county's past ordinance, and the other is a link to the State Attorney General's office, which has a basic summary of the status of tenant rights in California generally, but also to note that the portal, once we get it live, which will be in the next few weeks and before the January 1 date for reporting of evictions, will have summary information available there as well.
Great. Thank you very much. This next question comes from one of our anonymous viewers. The question is, does the Ellis Act pertain in this situation? Where can I find this law or information as it pertains to unincorporated areas of Sonoma County? This also concerns a senior tenant who has lived in his or her home for over 10 years.
So maybe, Paul, I'll talk to that in a general matter and
Sure.
over in case Patrick wants to make comments. But so the Ellis Act is the statewide law that allows landlords under specific circumstances to take a property off of the rental market. The ordinance that was passed by the County of Sonoma does not include Ellis Act procedures. So Ellis Act, what people usually mean when they talk about it are limitations on the manner in which a landlord can take a property off of the market, and Sonoma County has not opted in to establish its own limits. And then Patrick, if you want to talk about, to the extent it might apply to individuals on the more sort of narrower question of, what are allowable evictions under the Ellis Act, please feel.
Sure, I actually think that covers it perfectly. And the only thing that I would add is that the only jurisdiction in Sonoma County that does have limited Ellis Act protections, which, as Deputy Counsel Coleman stated, was limitations on the manner in which a landlord as a business owner can go out of business or take a property off of the rental market. The only jurisdiction in which that exists in a limited fashion is now in Petaluma in unincorporated Sonoma County. There are no Ellis protections under the new ordinance, and there are none to my knowledge in any city other than Petaluma.
Great. Thank you for explaining that. Next question is from Nina, who says, my 42-year-old boyfriend has been living and working as a ranch manager on a 135-acre property in Pengrove for the past 17 years in exchange for rent and a small stipend. There are no contracts were ever signed, but he may be facing eviction, and we have been unable to ascertain how his employment may impact eviction protocol. Can the property owner, his landlord, and employer circumvent the typical 60-day notice to quit and subsequent unlawful detainer process, etc.? Patrick, you want to take that one on?
Sure. So I can take that. So I'll preface in general that there's a very fact-specific question here. So Nina and anyone else who's concerned with sort of a very specific situation, my recommendation is to call our office. This is the sort of situation that we help low-income tenants throughout the county with all the time. In terms of a general rule, right, in agriculture, it's very common for someone's tenancy to be based on an employment contract. And the rights that that tenant has derive specifically from the employment contract. So in general, to really give an answer to what a tenant's rights might be, where they're an employee and their housing is based on their status as an employee, that's the sort of question that we would need to get directly to really be able to do a deep dive into the case. If I could give one more just piece of information that I think often confuses tenants and housing providers alike, it's that contracts do not always need to be written down to be enforceable as contracts. Lots of folks live in places where they pay rent, but there was never a lease agreement that was written down, signed by both parties. There is an enforceable lease agreement, even if it isn't written, if there's been an exchange for a place to live, whether that exchange is labor or money. And in terms of the specific rights that a tenant in that situation has, they would call us and we would do a full evaluation to advise them of their rights. But just because there's no written contract, in many cases, that doesn't mean that there isn't a valid tenancy to which certain rights attach.
Great. Thank you, Patrick. Here's a quick one. Maybe Elizabeth, you can address this. James asked, do these ordinances cover Monterey?
Monterey being an unincorporated portion of the county is covered. So all unincorporated areas are covered by the general terms here, and then broader areas of the county could be covered in an emergency depending on the scope of the board's invocation of the preposition emergency ordinance.
Because wouldn't there also be a difference between a multifamily housing project and a single family home there?
Yes.
Incorporated or not?
Absolutely. So a single family home, whether it's in unincorporated or unincorporated, will not be impacted. So they're not covered under state law or the county's expansion of state law. So, but the multifamily rental units within Monterey would be covered.
How many, can I ask a question here? How many units have to be like a duplex? Is that a multifamily unit or a fourplex?
A duplex are generally considered exempt where an owner occupies a portion of the property. And those are the parameters of that are set out in state law. But generally with ADUs and owner occupied duplexes, those are, and Patrick, feel free to jump in, because I wasn't prepared to talk about that. But those are generally exempted from the just cause protections, although some of those do have state level rent control protections nonetheless.
Yeah, so what Elizabeth said was correct, and I'll just supplement that. I think the rule, and again, to apply the rule to a specific situation, I think it's important to call lawyers, call us, or a private attorney who's well versed in these matters. But as a general rule, the sort of thing that the state law exemptions hinges on when we're not talking about single family homes is whether the owner is using the property as their primary residence. And when the owner is using it as their primary residence, in most cases, that property will exempt until it goes above a certain unit threshold on the same property, which I believe is when you have your third rental unit that is on a property that is owner occupied. That is the point at which state law protections kick in. And because state law protections kick in at that point, the county ordinance would also kick in.
Thank you.
Thank you for clarifying that. We have a question here. It's a little confusing, but I think the gist of it is that we have an attendee who is concerned, wants to know about how the California Tenant Protection Act just cause protections apply to someone who has Section 8 housing choice voucher. I think they're concerned about a tenant in Sonoma County who is approaching or on the verge of eviction, and they're wanting to know to what extent they're covered by this. I think that's the gist of their questions. Patrick, do you want to take that on?
I can, and then Elizabeth, if you want to supplement anything that I say. So a housing choice voucher, which is the kind of voucher, it's a subsidy that a person has that is administered by the housing authority. There are two housing authorities in Sonoma County. There's one for the city of Santa Rosa, and then there's one for everything that is not Santa Rosa, which includes unincorporated Sonoma County. Those vouchers are vouchers, or they're subsidies that the tenant can take with them to apply to any kind of housing for which they might be eligible. The presence of a voucher in the household, or the presence of a subsidy via the Housing Choice Voucher Program, does not determine either way whether the state law applies. What determines whether state law applies is what kind of housing does that person live in. If that person with the housing choice voucher lives in a single family home that's not owned by a real estate investment trust or a corporation, that person will have whatever protections their voucher guarantees them, but they will not have the protections of either state law just cause protections nor the county ordinance. So the voucher isn't the thing that makes the determination of whether state law or the county protections apply. It's still what kind of housing does this person live in?
I have nothing to add.
Okay. I hope this, thank you, Patrick. I hope this addresses the question of this particular anonymous attendee. I do encourage, there's a lot of nuance to this particular question. I do encourage this individual to call legal aid at that number that Patrick has supplied, 707-843-4432. And they can hopefully address any more questions that person has. Let me ask, well, first, Lois Hopkins wanted me to let everybody know that the county is in the process of building a website for tenant information. And this will include resources for tenants, and a link will be provided on the main county website, and that website should be up and running by the first week in November. So we will be promoting that information as well as soon as that website is available. Lois, is there anything else you wanted to provide about that?
No, that also will be the website for landlords to go in and submit their information. But again, that's being built. But yes, most of this information, the ordinance, the state statute and everything will be available on that website.
Okay, thank you. I want to go to a question by Shelley, one of our followers. She asks, how often can a property manager raise the rent in unincorporated areas? And the question being, can they push out tenants by raising rents continuously? Patrick, I'm going to go to you first as well. What do you think?
Sure. So under the Tenant Protection Act, which does have a basic rent stabilization aspect to it that we really haven't covered much here. We did more focus on the just cause, but there's a rent stabilization portion to the Tenant Protection Act. If a property is covered by the Tenant Protection Act, then the rent cannot be raised more than 5% plus the annual rate of inflation, or 10% whichever of those two numbers is less. That gets a little complicated, so trying to make it easy, right? Inflation numbers are roughly around between 2.5% and 3% over the past year. You add 5% to that number, and that means for a property that has the state protections, a year-over-year rent increase should not be more than roughly 7.5% to 8% from what it was at the same time last year. I cannot remember off the top of my head how many different times a landlord might be able to raise the rent in order to reach that ceiling. I believe they might have access. Well, I don't want to misspeak. And Elizabeth, if you remember the answer to that question, you can chime in and supplement. But the cumulative amount of the rent increase from one year to the same time the next year is 5% plus inflation, which right now would be about 7.5%, 8% total, or in a time with high inflation, it would be capped at 10%. Now that's only for properties where the state protections apply. So again, we're not talking about most single family homes. We're not talking about housing that is younger than 15 years. The protection that does apply for folks that just live in, general single family homes or relatively new housing, is that the landlord does have to raise the rent via a valid notice. And if the rent is over 10%, state law says that that person needs to at least have a 90-day notice before the rent increase can go into effect. The idea being that the tenant needs a long runway to make a plan for themselves if the landlord wants to raise the rent 10, 12, 13%, more than that. So they get 90 days notice before a rent increase can go into effect. But substantively, a landlord may raise the rent as many times as they want, as long as they do so in a valid manner, if the property is not covered by those state protections.
I'll just jump in to add that the limit is 2 times in a 12-month period that a rent can be raised, but of course that does not change the substantive maximum of the annual increase.
I never knew that. Thank you. Thank you both. Let me jump down. James asks, I think this is a follow-up from a previous answer. He asks, how can I find out if my landlord has the property held in an LLC or a real estate investment trust? Anybody want to take a shot at that one?
I think sort of getting more to the question of whether the property is exempt, there are notification requirements built into state law under which landlords need to tell you at the start of a tenancy if the property is in fact exempt as being owned by a single family resident. So as a general matter, the ownership of properties is listed on the deeds, which are searchable in county records, but to the question of whether a property specifically is exempt from just cause under the state law, Patrick, please correct me if your understanding is different, but at the commencement of a tenancy, you should be provided that information.
Correct. Though we've been saying that the single family homes are largely exempt from the Tenant Protection Act, it is important to understand that that exemption needs to be affirmatively claimed by the housing provider by giving notice to the tenant that it is in fact exempt. So essentially all properties are assumed not exempt from the state protections until the property owner provides the notice that Elizabeth was talking about, letting the tenant know that it is not owned by a corporation or a real estate investment trust, and therefore the property is exempt.
Great, thank you. Let me offer a comment. Keith, who's one of our landlord friends, is joining us this evening, makes the comment that the presumed concern that once COVID protections lapsed, landlords would overwhelm tenants with unlawful detainers is shown to be inaccurate. He wanted to leave that comment. Thank you, Keith. I also want to Cynthia asks that she notes that she's unable to stay for the forum tonight. She asked, will the recording be available for later viewing? Yes, this meeting is being recorded, and will be available to view on the county's website as well as on Facebook and on YouTube. And just a reminder that the date for our landlord-specific webinar targeted for answering questions from our landlords will be on November 19th at 6 p.m. Anyway, I think we've addressed a lot of our questions. I'm not sure there are any others that we have not addressed at this time. Does anybody else have anything they want to add that comes to mind at this point?
Paul, actually, I would like to ask a question.
Yes,
If I
please.
could. If I am a tenant and I submit my rent and it's my rent is $1,000 and I'm only able to provide $700. So my rent is, my payment is $300 less, but at some point during the month, I pay that additional $300. And then the next month, I'm another $300 behind. So I have, and I pay that 300, but it's late. So I have availed myself of the 2 times a year that I can not do my full rent. Would a landlord be able to evict me if I did that a 3rd time? This is kind of to Patrick and Elizabeth.
The ordinance is written such that you have a defense to unlawful detainer that can be invoked twice. So, you know, it would sort of depend on the facts as to what the landlord did when you underpaid the rent. But yeah, I mean, I would say that procedurally, if a person did not pay their whole rent on 2 different months, then it is likely that on the 3rd time they would in fact be evictable, even if it was not because you can only avail yourself of the limitation that you have to be a month behind before it counts for eviction purposes. You can only use that twice. So whether it's a little bit behind or a lot behind, that's how I would read it. But that would also ultimately be for a court to decide, you know, because Sonoma County does write the rules, but because the enforcement mechanism for the rules is actually the courts in the unlawful detainer proceedings, you know, some of the ways that the court's going to read those rules will, you know, particularly in marginal questions like that, we could be surprised.
I see. Because I think there is a difference if a tenant just doesn't pay the rent versus they're a little behind and they need, you know, a couple weeks to catch up. But thank you. Thank you for that. And
Lois, if I might add, just because I think this is a question that probably lots of folks have and folks who might listen to this later on. This is not, I think Elizabeth covered the legal side of this very well. I think as a practical matter for tenants, and part of the reason that I believe this part of the ordinance was put into place is that, you know, the county wants to help folks who have momentary sort of work stoppages, or, you know, they have a hard month, they have medical bills they didn't anticipate, to have a little bit of breathing room to get caught up before their housing is taken away from them. The intention is not to have housing providers sort of carry rental debt in larger and larger amounts forever and ever. And I think one thing that is really helpful for me, even as an attorney with the legal side, is before I have to take something to court and make a legal argument for someone, it's good when a tenant has availed themselves of all the opportunities to create a relationship with the property manager, to talk about what they're going through, to try to work things out amicably before things end up in court. And I do find, you know, despite being a lawyer that assists, you know, tenants and works primarily on the tenant side, that we do have a lot of property managers in Sonoma County that work very hard to work with their tenants, especially those who have had momentary issues that have, you know, caused them to fall behind and are working hard to get caught up. So I think having an open line of communication between tenants and housing providers and property managers is important. And it does help from things ever getting to that point where we're asking a court to make a legal determination of who's right and who's wrong.
Mm-hmm. Thank you.
Thank you. Elaine has a follow-up question. She asks, I want to make sure I understand what was explained regarding the Ellis Act, state law. I heard it isn't enforced if the county hasn't adopted it or something like that, and that only Petaluma follows the Ellis Act. She says, I'm sorry if I'm not using the right legal terms. Does anybody want to help clarify?
Sure. Yeah. I mean, the Ellis Act, and don't apologize. It's confusing and it's sort of opt-in and sort of not. So the Ellis Act does, as a general matter, talk about properly taking a property out of the rental market and creates that as a proper basis for terminating a tenancy. But you're correct that in terms of the protections that it creates for some tenants, it is an opt-in. A jurisdiction must first have adopted a rent control scheme and can simultaneously or thereafter adopt Ellis Act protections. And what those do, they'll say, for example, you need 90 days worth of written notice. You have to give a certain amount of notice to teachers or folks with small children in the house, right? So they can add substantive protections that say how a landlord has to go about pulling a property off the market, and then what they have to do, in terms of offering it back before putting it back on the market if they ultimately do try to rent it out again. So the Ellis Act in the general sense applies all statewide, but as far as it impacts folks on the day-to-day, you're correct, it is opt-in, and Petaluma has itself adopted an Ellis Act statute that that avails itself of those protections for tenants. But Sonoma County did not adopt an Ellis Act program, and none of the other, as Patrick mentioned, I don't believe any of the other municipalities in Sonoma County have done so.
Thank you for clarifying. We had one guest ask, what kind of guest visitation restrictions can lawfully be placed on tenants by a landlord? And I guess by extension, could that be used as for a just cause eviction? That also was mentioned earlier. Patrick, do you want to take a stab at that?
Sure. So this is a pretty hard question to answer. It's very fact intensive. Generally, certain reasonable limitations on guest visitation is set by a lease agreement. And there are, per my earlier answer about sort of older folks and folks with disabilities, right? There might be certain kind of carve outs for guests that might be related to a disability. Somebody needs a caretaker to be with them at certain hours of the day. There's the in-home support services program that's administered by the county that requires sometimes even live-in caretakers for folks with disabilities. For folks that are truly guests, generally the rules around guest visitation are set by the lease. And so I would have to look at somebody's lease agreement to understand what the restrictions on guest visitation are that would apply to that person's tenancy.
Okay. Well, I think we have a number of people saying thank you for acknowledging their questions. Thank you for the advice. A few say they do plan to follow up with legal aid with their specific questions. A couple have asked about the upcoming webinars, which again, the next one will be for landlords on November 19th at 6 p.m. We also will be having in-person outreach events, which we hope to have our first one in December. And with that, I think we are addressed all of the questions. I'm going to reach out to Supervisor Corsi to ask if he has any final comments, or any of our panelists have any final thoughts.
Thanks, Paul. And I just want to thank everybody for participating tonight. As stated at the beginning, this is a complicated issue. We had a question from a member of the community about how we're going to help the community understand this. And I think that all I can say is that we're going to continue answering questions. We're going to continue reaching out, and we're going to make ourselves available both on the county side and on our nonprofit partner, the legal aid side. So this is the beginning, not the end. And thank you for kicking us off.
And Patrick or Elizabeth, any final thoughts?
Not for me. Thanks for your patience with the details.
And I'll just thank the county, all of the attendees, and the county counsel's office for and the county administrator's office for all the work that they've done on putting this together. And then lastly, I'll just reiterate for folks that are listening and maybe have access to a pen or pencil, Legal Aid's housing line is 707-843-4432. And our office is at 144 South E, like the letter E for Edgar, Street in Santa Rosa. We are close to Santa Rosa City Hall and right on the Mayacamas Creek for folks that want to come visit us in person.
Yes, and we want to just thank all of you for a great discussion, a really important information. As a reminder, we did provide a number of links in the answers today. You also can find out more information about the county's tenant protections by going to sonomacounty.ca.gov/tenant protections, or by emailing us at publicaffairs@sonoma-county.org, or just Googling Sonoma County tenant protections, and that will take you to press releases as well as the ordinance itself. We're happy to make sure you have the information that you need, and we will be pushing out information about upcoming webinars and in-person events to get this information out. So we thank you all for joining us. Great questions, and we wish you a very pleasant evening. Thank you.